Kia ora, nama ki te whare. Welcome to The House, ko Louis Collins aho. Earlier this month, I sat down with Jeff Macleay, Dean of Law at Victoria University, to chat about Parliament's relationship with the courts. In particular, I was interested in cases where a judicial ruling prompts a minister to reconsider legislation. In New Zealand, Parliament is supreme, and if lawmakers disagree with how courts have interpreted legislation, they ultimately have the authority to change it. Here's an excerpt from my chat with Macleay.
If a judge says you can't do what you thought the statute said you could do, you just can't do it. But of course, what a minister can do is a minister can go back to Parliament and say, I need the law to be changed because this is not in accordance with what I thought it was, what it needs to be, what New Zealand needs it to be. And that's also a natural process of our constitution, that Parliament is entitled to change the law, just as it's the judge's role to interpret the law. And of course, then you have a controversy because the people who have won the court case will say, well, we won a court case. It's wrong for you now to go and remove the fruits of the judgment from us. And in fact, one of the conventions of the New Zealand Constitution has often been that we don't reverse the particular case that's happened, but we might say in the future, the law needs to be different. And so that's often what Parliament does in response to a particular court decision. It will go away and change the law. The real controversy at the moment is in relation to some decisions. So, for example, in relation to foreshore and seabed legislation, where the Supreme Court gave a particular interpretation which the ministers did not like of the way in which the key provision of that statute was to be interpreted, the provision about what iwi and hapu needed to establish in terms of their exclusive possession of a particular part of the foreshore. The ministers don't like the interpretation that was given. There's a bill in Parliament to change that. The Supreme Court gave a ruling. The ministers stopped the consideration of the bill in Parliament while they considered what the Supreme Court said, and then they're continuing on with changing the law.
That bill Professor Macleay is referring to is the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill, which passed its third and final reading in the House last night. Minister-in-charge Paul Goldsmith reiterated that the bill is aimed at restoring Parliament's original intent behind the 2011 legislation.
Our view is that the government's view is that the courts have interpreted the requirements for the test for customary marine title in a way that has materially reduced their intended effect to the point where it was necessary to take action to ensure the Act operates as originally intended.
In what is quite rare for legislation, the bill will override judicial decisions made after the 25th of July last year, which is when the government announced their intentions to introduce the bill. Here's Goldsmith explaining why the government chose to break the norm.
Retrospective provisions in legislation are reserved for exceptional circumstances, and these are exceptional. The current approach to the test by the courts is damaging to the Takutai Moana process as a whole. If the bill has prospective effect only, it would be unfair to those applicants who, by way of scheduling, would be subject to a stricter restored test, while others retain awards under what Parliament regards as an incorrect interpretation of the legislation.
Professor Macleay notes that while retrospective provisions can be constitutionally above board, they do raise important considerations when Parliament decides to use them.
What do you do with cases that are currently on foot, cases that are already filed? And one of the conventions we've tended to have in New Zealand is that if you've already filed your case, it should be determined under the old law. So you don't have the rules of the game changed on you as you go forward. And the foreshore and seabed legislation does some sort of alters those understandings a little bit. And that could be a concern. And secondly, then you get another part of the New Zealand Constitution, which is in this Maori-Crown relationship space, where many people would say that actually there's a broader constitutional significance to this legislation. There's a broader constitutional significance to the court decisions as a result of that and a result of the relationship between Crown and Maori, and that Parliament should be very reluctant to intervene in changing the particular tests. And there's been quite a lot of public controversy over that.
Some of that public controversy was voiced by Labour MP Jenny Anderson, who rejected Goldsmith's framing of the bill as merely restoring original legislative intent.
This bill is not, as the government insists, a tidy clarification of an old law. It is an incredibly blunt instrument that tears at the very foundations of justice, upends our court processes and undermines a hard-fought relationship between Te iwi Māori and the Crown. We are told that it will restore Parliament's original intention, but in truth, Madam Speaker, it rewrites that intention, it narrows it, and it applies new rules retrospectively, overturning the work of the courts and reopening wounds. I'm going to lay out the 3 key reasons that I'm opposed to it. Those 3 are that it rewrites the legal test for customary title to make it virtually impossible. Secondly, it applies the rules retrospectively, undermining the rule of law and basic fairness in New Zealand. And thirdly, it damages the Crown-Māori relationship.
With all 3 government parties voting in favour, the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill will likely be signed into law next week. I te whakarongo koe ki te whare. You've been listening to The House, a program made with funding from Parliament's Office of the Clerk. Matua.